In England, at least until the mid-1600s, and arguably until William Blackstone's time in the mid-1700s, property was exclusively owned by the king. In arbitrary governments, the title is held by and springs from the supreme head, be he the emperor, king, dictator, or by whatever name he is known. It was stated, and thus a known fact, that if the king felt it justified, he could just take the land from one baron and give such land to another prospective baron. The king was the true and complete owner, giving him the authority to take and grant the land from the people in his kingdom to who either lost or gained his favor. McConnell versus Wilcox, 1837. This is hardly what the forefathers planned, for when creating the United States Constitution, if this were what the people in the mid to late 1700s wanted, there would have been no need to have an American Revolution, since the taxes were secondary to having a sound and complete ownership of the land. When the colonists were forced to pay taxes and were required to allow their homes to be occupied by soldiers, they revolted, fighting the British and declaring their Declaration of Independence. The colonists came to America to avoid taxation without representation, to avoid persecution of religious freedom, to escape sovereign control and virtual dictatorship over the land, and to acquire a small tract of land that could be owned completely. Having broken away from the English sovereignty and establishing themselves as their own sovereigns and equally important ownership of the land, the American founding fathers chose a loyal ownership of land for this system of ownership in this country. Wendell versus Crandall, 1848. The American people, before developing a properly functioning stable government, developed a stable system of land ownership whereby the people owned their land absolutely and in a manner similar to the king in common law England. As allodium, which means or is defined as man's own land, which he possesses merely in his own right, without owing or any rent or service to any superior. Wallace versus Harmstead, 1863. Allodium, Black's Law Dictionary, 6th edition. Land held absolutely in one's own right, and not of any lord or superior. Land not subject to feudal duties or burdens. An estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. The American people, newly established sovereigns in this republic after the victory achieved during the Revolutionary War, became complete owners in their land, beholden to no lord or superior. As sovereign freeholders in the land themselves, these freeholders in the original 13 states now held allodial the land they possessed before the war only feudally. Chisholm versus Georgia, 1837, as quoted in Leading Fighter versus County of Gregory in 1975. Perpetuity, Black's Law Dictionary, 5th edition. Continuing forever, legally, pertaining to real property. Any condition extending the inalienability in terms of an allodial title, it is to have the property of inalienability forever. Nothing more need be done to establish the ownership of the sovereigns to their land, although confirmations were usually required to avoid possible future title confrontations. After the American Revolution, lands in this state, Maryland, became allodial, subject to no tenure nor to any services incident thereto, as stated in R.E. Waltz et al. Barlow versus Security Trust and Savings Bank, 1925, quoting Matthews v. Ward, 1839. Allodial, Black's Law Dictionary, 6th edition. Free, not holden of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal. An estate of inheritance without condition, belonging to the owner and alienable by him, transmissible to his heirs, absolutely and simply. Such an estate is an absolute estate in perpetuity and the largest possible estate a man can have, being, in fact, allodial in its nature. This type of fee simple as thus developed, has definite characteristics. 1. It is a present estate in land that is of indefinite duration. 2. It is freely alienable. 3. It carries with it the right of possession. And most importantly, 4. The holder may make use of any portion of the freehold without being beholden to any persons. Stanton v. Sullivan, 1839. The United States Supreme Court and state courts alike have stated as a matter of fact from the very first day, as in the case of Chisholm v. Georgia, 1793, up to and beyond Leading Fighter v. County of Gregory, 1975, that the United States Constitution secured the sovereign people the substantive right to own land, absolute in perpetuity, establishing ownership and possession, not subject to any lord, superior, feudal duties, or burdens, and without obligation of vassalage. In doing so, a government of and for the people was thereby established to protect the people's sovereign right to a allodial title of the land subject to no tenure as in the title at law, which establishes an allodial freehold that is judgment-proof and even immune from taxation. This type of superior title was bestowed upon the newly established American people by the Founding Fathers. The people were sovereigns by choice, and through this new type of land ownership, the people were sovereign freeholders or kings over their own land, beholden to no lord or superior. United States v. Sunset Cemetery Company, 1943. When the Constitution was drafted, the Founding Fathers were very clear that they did not want the country to be run on the backs of the people, as in their labor and their land. See Federalist number 30. Once again, if this were what the people in the late 1700s wanted, there would have been no need to have an American Revolution. Constitution, Article 1, Section 8, Clause 1, clearly defines the limitation of taxation to duties, imposts, and excises to be the only form of taxation to pay debts of and to provide for the needs of the government. U.S. Constitution, Article 1, Section 8, Clause 1. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. Note, when a definition is encounter in the law defines the word to purposely exclude the word from the common definition, not to add to the common meaning or definition. 73, American Jurisprudence, 2D, subsection 146, operation of legislative definitions generally. The lawmaking body's own construction of its language, by means of definitions of the term employed, should be followed in the interpretation of the act or section to which it relates and is intended to apply. By the same token, the courts should not enlarge statutory definitions so as to include a situation or a condition which it might be assumed the legislature would have covered by an enlarged definition if its existence had been contemplated. A statutory definition supersedes the common law and commonly accepted dictionary or judicial definition. In this regard, where statute itself contains a definition of a word used therein, the definition controls, however contrary to the ordinary meaning of the word it may be, and the term may not be given the meaning in which it is employed in another statute, although the two may be in pari material. Where the legislature has defined words which are employed in a statute, its definitions are binding on the courts, since the legislature has the right to give such signification as it deems proper to any word or phrase used by the statute, irrespective of the relationship of the definition to other terms. Furthermore, where a word that already has a definite fixed and unambiguous meaning is redefined in a statute, the definition must be taken literally by the courts. U.S. Constitution, Article 1, Section 8. Congress shall have power to lay and collect taxes, duties, imposts, and excises. Taxes. Black's Law Dictionary, 6th edition. The apportionment of a tax consists in a selection of the subjects to be taxed, and laying down the rule by which to measure the contribution which each of these subjects shall make to the tax. Taxes. Bouvier, 1856, 6th edition. This term, in its most extended sense, includes all contributions imposed by the government upon individuals for the service of the state, by whatever name they are called or known, whether by the name of tribute, tithe, talliage, impost, duty, gabel, custom, subsidy, aid, supply, excise, or other name. U.S. Constitution, Article 1, Section 8. Congress shall have power to lay and collect taxes, duties, imposts, excises, to pay and see, but all duties, imposts, and excises shall be uniform throughout the United States. In the sense just mentioned, taxes are usually divided into two great classes, those which are direct and those which are indirect. Under the former denomination are included taxes on land or real property, and under the latter, taxes on articles of consumption. Congress has plenary power over every species of taxable property except exports, but there are two rules prescribed for their government, the rule of uniformity and the rule of apportionment. Three kinds of taxes, namely duties, imposts, and excises, are to be laid by the first rule, and capitation and other direct taxes by the second rule. Should there be any other species of taxes not direct and not included within the words duties, imposts, or customs, they might be laid by the rule of uniformity, or not, as Congress should think proper and reasonable. The word taxes is, in a more confined sense, sometimes applied in contradistinction to duties, imposts, and excises. Vide, generally, Story on the Constitution, C14. The Federalist, number 21. Excise tax. Black's Law Dictionary, 6th edition. A tax imposed on the performance of an act, the engaging in an occupation, or the employment of a privilege. A tax on manufacture, sale, or use of goods, or on the carrying on of an occupation or activity, or a tax on the transfer of property. In current usage, the term has been extended to include various license fees and practically every internal revenue tax except the income tax, e.g. federal alcohol and tobacco excess taxes, IRC, subsection 5001, Rapa versus Haynes, Ohio. Excises. Bouvier, 1856 edition. This word is used to signify an inland imposition, paid sometimes upon the consumption of the commodity and frequently upon the retail sale. Imposts. Black's Law Dictionary, 6th edition. Taxes, duties, or impositions levied for diverse reasons. Crew Levick Company versus Commonwealth of Pennsylvania. Imposts. Bouvier, 1856 edition. This word is sometimes used to signify taxes or duties or impositions, and sometimes in the more restrained sense of a duty on imported goods and merchandise. The Federalist, number 30. Imposts. Bouvier, 1856 edition, Part 2. The Constitution of the United States, Article 1, Section 8, gives power to Congress to lay and collect taxes, duties, imposts, and excises. And Article 1, Section 10, directs that no state shall without the consent of Congress lay any impost or duties on imports or exports except what may be absolutely necessary for executing its inspection laws. Duties. Black's Law Dictionary, 6th edition. In its most usual signification, this word is the synonym of impost or customs, i.e. tax on imports, but it is sometimes used in a broader sense, as including all manner of taxes, charges, or governmental imposition. Duties. Bouvier's 1856 edition. In its most enlarged sense, this word is nearly equivalent to taxes, embracing all impositions or charges levied on persons or things. In its more restrained sense, it is often used as equivalent to customs or imposts. Story Constitution 949 via for the rate of duties payable on goods and merchandise. Title 26, Volume 1, revised as of April 1st, 2008, from the U.S. Government Printing Office via GPO Access. Part 1, Income Taxes. Table of Contents, revised as of April 1, 2008. Section 1.441-1, period for computation of the taxable income. Section 8, Taxpayer. Taxpayer has the same meaning as the term person as defined in Section 7701A1, e.g., an individual, trust, estate, partnership, association, or corporation, rather than the meaning of the term taxpayer as defined in subsection 7701A14, any person subject to tax. Individual. Black's Law Dictionary, 6th edition. As a noun, this term denotes a single person as distinguished from a group or class, and also, very commonly, a private or natural person as distinguished from a partnership, corporation, or association. But it is said that this restrictive signification is not necessarily inherent in the word, and that it may, in proper case, include artificial persons. As an adjective, individual means pertaining or belonging to or characteristic of one single person, either in opposition to a firm, association, or corporation, or considered in his relation thereto. 26 U.S.C. subsection 7701, Title 26, Internal Revenue Code, Subtitle F, Procedure and Administration. Section 7701, Definitions. A. When used in this title, where not otherwise distinctly expressed or manifestly incompatible with the intent thereof. Section 1. Person. The term person shall be construed to mean and include an individual, a trust, a state, partnership, association, company, or corporation. Section 14. Taxpayer. The term person shall be construed to mean and include an individual, a trust, a state, partnership, association, company, or corporation. Florida Statutes, Chapter 198, Estate Taxes, FS, subsection 198.01, Definitions. When used in this chapter, the term, phrase, or word, subsection 3, person, means persons, corporations, associations, joint stock companies, and business trusts. Florida Statutes, Chapter 192, Taxation, General Provisions, FS, subsection 192.001, Definitions. The following definitions shall apply in the imposition of ad valorem taxes. Subsection 13, taxpayer, means the person or other legal entity in whose name property is assessed, including an agent of a timeshare, period, title holder. Florida Statutes, Chapter 220, Income Tax Code, FS, subsection 220.03, Definitions. Subsection 13, taxpayer, means the person or other legal entity in whose name property is assessed, including an agent of a timeshare, period, title holder. Florida Administrative Code, 12D, 2.001, Definitions. The following definitions shall apply to property assessed by the Department. Subsection 10, person, as defined in Section 1.01, Florida Statutes, and including any company. Unless otherwise specifically provided, the word company may be used interchangeably with the word person. Florida Statutes, FS, subsection 1.01, Definitions. In construing these statutes and each and every word, phrase, or part hereof, where the context will permit, Section 3, person, includes individuals, children, firms, associations, joint adventures, partnerships, estates, trusts, business trusts, syndicates, fiduciaries, corporations, and all other groups or combinations. Person. Black's Law Dictionary, 6th edition. In general usage, a human being, i.e. natural person, though by statute term may include labor organizations, partnerships, associations, corporations, legal representatives, trustees, trustees in bankruptcy, or receivers. In common usage, the term person does not include the sovereign, and statutes employing the word are ordinarily construed to exclude it. Wilson versus Omaha Indian Tribe, 1979. Situs, Latin, Black's Law Dictionary, 6th edition. Location or place of crime or business, or the right or power to tax it. Situs of property, for tax purposes, is determined by whether the taxing state has sufficient contact with the personal property sought to be taxed to justify in fairness the particular tax. Town of Katy versus Alexander Construction Company. Business situs, Black's Law Dictionary, 6th edition. A situs acquired for tax purposes by one who has carried on business in the state more or less permanent in its nature. A situs arising when notes, mortgages, tax sale, certificates, and like are brought into the state for something more than a temporary purpose and are devoted to some business use there and thus become incorporated with the property of the state for revenue purpose. Business situs continued. A situs arising where possession and control of property right has been localized in some independent business or investment away from owner's domicile, so that it is substantial use and value primarily attached to and become an asset of the outside business. State versus Atlantic Oil Producing Company. Tax situs, Black's Law Dictionary, 6th edition. A state or jurisdiction which has a substantial relationship to assets subject to taxation. Situs, Bouvier, 1856 edition. Situation, location. 2. Real estate has always a fixed situs, while personal estate has no such fixed situs. The law REI site regulates real but not the personal estate. Ad valorem tax, Black's Law Dictionary, 6th edition. According to value, a tax levied on property or an article of commerce in proportion to its value, as determined by assessment or appraisal. Callaway versus City of Overland Park. Ad valorem, Bouvier, 1856 edition. According to the value. This Latin term is used in commerce in reference to certain duties called ad valorem duties, which are levied on commodities at certain rates per centum on their value. See Duties, Imposts, Act of Congress of March 2, 1799. Because an owner-occupied residence not used for any commercial purpose does not qualify as property used in commerce or commerce-affecting activity, arson of such a dwelling is not subject to prosecution. Jones versus United States, May 22, 2000. Property tax, Black's Law Dictionary, 6th edition, page 1458. Generic term describing a tax levied on the basis of the value of either personal or real property owned by the taxpayer. Actual market value, Black's Law Dictionary, 6th edition. In custom laws, the price at which merchandise is freely offered for sale to all purchasers. The price which the manufacturer or owner would have received for merchandise, sold in the ordinary course of trade in the usual wholesale quantities. The U.S. Constitution clearly defines the limitation of taxation on duties, imposts, and excises of taxable property, except exports. The two rules prescribed by the U.S. Constitution are the rule of uniformity and the rule of apportionment, and the three kinds of taxes, namely duties, imposts, and excises, all commercial terms in accordance with the above statutory and legal definitions, truly involving a connection with manufacturing, trade, and traffic, including buying and selling, as in business activity, or commerce in general conducted within the situs of the state by some legal entity clearly defined by the Florida State Statutes, subsection 192.001, subsection 13, and subsection 220.03, Z as the taxpayer. The construction of the U.S. Constitution, Florida State Constitution, the Florida State Statutes, and the Florida Administrative Code makes it obviously clear whose property is lawfully intended to be regulated, taxed, and controlled, and which person is liable to pay such a tax and clearly states the exemptions from all taxations of such person. Keep in mind that all government codes, rules, regulations, and statutes can only apply to the state's sovereign lands, government employees, and what government is or has created. Even the municipal corporation, known to most as local government, cannot violate the constitutional rights of the people to fund its functions. Florida State Constitution, Article 7, Section 3B, Taxes, Exemptions. There shall be exempt from taxation, cumulatively, to every head of a family residing in this state, household goods, and personal effects to the value fixed by general law. Florida Statutes, Section 196.181, Exemption of household goods and personal effects. There shall be exempt from taxation to every person residing and making his or her permanent home in this state, household goods and personal effects. Title to such household goods and personal effects may be held individually by the entireties, jointly, or in common with others. Florida Administrative Code 12D-7.002, Exemption of household goods and personal effects. Only household goods and personal effects of the taxpayer which are actually employed in the use of serving the creature comforts of the owner and not held for commercial purposes are entitled to the exemption provided by Section 196.181 Florida statutes. Creature comforts are things which give bodily comfort such as food, clothing, and shelter. Commercial purposes include owning household goods and personal effects as stock in trade or as furnishings in rental dwelling units. The Florida State Constitution, Article 7, Section 6A, states, every person who has the legal or equitable title to real estate and maintains thereon the permanent residence of the owner or another legally or naturally dependent upon the owner shall be exempt from taxation thereon. The real estate may be held by legal or equitable title by the entireties, jointly, in common, as a condominium, or indirectly by stock ownership or membership representing the owner's or member's proprietary interest in a corporation owning a fee or a leasehold initially in excess of 98 years. Florida Statutes, Section 196.031, Exemption of Homesteads. 1. Every person who, on January 1st, has the legal title or beneficial title in equity to real property in this state and who resides thereon and in good faith makes the same his or her permanent residence, or the permanent residence of another or others legally or naturally dependent upon such person, is entitled to an exemption from all taxation. Florida Statutes, Section 195.027, Rules and Regulations. 1. The Department of Revenue shall prescribe reasonable rules and regulations for the assessing and collecting of taxes, and such rules and regulations shall be followed by the property appraisers, tax collectors, clerks of the city circuit court, and value adjustment boards. It is hereby declared to be the legislative intent that the department shall formulate such rules and regulations that property will be assessed, taxes will be collected, and the administration will be uniform, just, and otherwise in compliance with the requirements of the general law and the Constitution. House, Black's Law Dictionary, 6th edition. Structure that serves as living quarters for one or more persons or families. Shelter, Black's Law Dictionary, 6th edition. In statute relating to the provisions of food, clothing, and shelter for one's children, term generally refers to a home with proper environments as well as protection from the weather. Household, adjective, Black's Law Dictionary, 6th edition, belonging to the house and family, domestic. Home, Black's Law Dictionary, 6th edition, one's own dwelling place, the house in which one lives, especially the house in which one lives with his family, the habitual abode of one's family, a dwelling house. Man versus Hines. Comfort, Black's Law Dictionary, 6th edition, benefit, consolation, contentment, ease, enjoyment, happiness, pleasure, or satisfaction. Personal effects, Black's Law Dictionary, 6th edition, articles associated with person as property having more or less intimate relation to person of possessor. Effects, meaning movable or chattel property of any kind. Usual reference is to such items as the following owned by a decedent at the time of death: clothing, furniture, jewelry, stamp and coin collections, silver, china, crystal, cooking utensils, books, cars, television, radios, etc. Household, noun, Black's Law Dictionary, 6th edition. A family living together. Schurler versus Industrial Commission. Those who dwell under the same roof and compose a family. Term household is generally synonymous with family for insurance purposes and includes those who dwell together as a family under the same roof. Van Overbeek versus State Farm Mutual Auto Insurance. Generally, the term household is used in automobile policies is synonymous with home and family. Bartholet versus Berkness. The Florida State Statutes, Section 192.001-13 and Section 220.03Z defines the taxpayer as a corporation or other legal entity, and that the word taxpayer has the same meaning as the term person pursuant to Title 26 CFR Section 1.441-1, Section 8. Florida Statutes, Section 198.01-3, and the Administrative Code 12D-7.002 defines household goods and personal effects of the taxpayer to be creature comforts, things which give bodily comfort such as food, clothing, and shelter, and states that such creature comforts shall be exempt from taxation. To reiterate, the Black's Law Dictionary, 6th edition, defines shelter as a term generally refers to a home, and as well as protection from the weather. It also defines the word home as a house, one's own dwelling place, the house in which one lives with his family, a dwelling house. Also, it defines household as belonging to the house and family. Also, generally, the term household, as used in the automobile policies, is synonymous with home. The Florida State Constitution, Article 7, Section 3B, states that those household goods and personal effects to every head of family residing in this state are exempt from taxation. The Florida State Statute, Section 196.181, Exemptions Chapter, makes it very clear that the title to such household goods and personal effects shall be exempt from taxation, and Florida State Statute FS 196.031 Exemptions Chapter tells us that every person who has the legal title or beneficial title in equity to real property in this state and who resides thereon and in good faith makes the same his or her permanent residence, or the permanent residence of another or others legally or naturally dependent upon such person, is entitled to an exemption from all taxation. The Florida State Constitution, Article 7, Section 6A, states that every person who has the legal or equitable title to real estate and maintains thereon the permanent residence of the owner, or another legally or naturally dependent upon the owner, shall be exempt from taxation thereon. Florida Statute Section 195.027 Rules and Regulations make it very clear that the legislative intent is to be in compliance with the requirements of the general law and the Constitution. Title, Black's Law Dictionary, 6th edition. Title is the means whereby the owner of lands has the just possession of his property, the union of all the elements which constitute ownership, full, independent, and fee ownership, the right to or ownership in land, also the evidence of such ownership. Such ownership may be held individually, jointly, in common, or in cooperate or partnership form. One who holds vested rights in property is said to have the title whether he holds them for his own benefit or for the benefit of another. Ownership, Black's Law Dictionary, 5th edition. The complete dominion, title, or property right in a thing or claim, the entirety of the powers of use and disposal by law, the exclusive right of possession, enjoyment, and disposal. Ownership of property is absolute or qualified. The ownership of property is absolute when a single person has absolute dominion over the property. The ownership is qualified when use of the property is restricted. Note: so one must ask themselves, what do we have title to? The couch, the TVs, lamps, tables, beds, or the DVD and CD collection, or maybe the refrigerator. No, we have title to the land and the structures, houses, barns, sheds, etc., that sit upon that land in the allodial sense, as in complete perpetuity, not holden of any lord or superior, owner without obligation as granted by the original land patents and protected by the state and federal constitutions. State courts across the nation have, over the past 200 years, have ruled that question of legal title cannot be tried or decided. Merrill versus Wright, Schneck versus Conover, Exum versus Baker, and Stanley versus Sullivan. This technically tells us that the land ownership in America is truly absolute. Therefore, no lawful court of the land can even hear the matter involving legal title, because there can be no lawful claim against one who holds legal title. Legal title is absolute and held in complete perpetuity. Commercial use, Black's Law Dictionary, 6th edition. Term implies use in connection with or for furtherance of a profit-making enterprise. Roberts Enterprises, Inc. versus Secretary of Transportation. As just stated, household goods and personal effects are defined technically as things which give bodily comfort, such as shelter, house, and that the title to such household goods and personal effects, house and the land it sits upon, used solely for the creature comforts of the taxpayer/owner, and not devoted to some business or commercial purposes, shall be exempt from taxation. Therefore, the use of such property solely for exempt purposes, as in non-business, non-commercial, non-profit use, is expressly exempted from taxation. Remember, the legislative intent is to be in compliance with the requirements of the general law and the Constitution. Florida Statutes, Section 196.012, Definitions. For the purpose of this chapter, the following terms are defined as follows, except where the context clearly indicates otherwise. Section 2. Exclusive use of property means use of property solely for the exempt purposes. Such purposes may include more than one class of exempt use. Section 13. Real estate used and owned as a homestead means real property to the extent provided in subsection 6A, Article 7 of the state constitution, but less any portion thereof used for commercial purposes, with the title of such property being recorded in the official records of the county in which the property is located. Property rented for more than 6 months is presumed to be used for commercial purposes. Section 17. Permanent resident means a person who has established a permanent residence as defined in subsection 18. Subsection 18. Permanent residence means that the place where a person has his or her true, fixed, and permanent home and principal establishment to which, whenever absent, he or she has the intention of returning. A person may have only one permanent residence at a time, and once a permanent residence is established in a foreign state or country, it is presumed to continue until the person shows that a change has occurred. Commercial, Black's Law Dictionary, 6th edition, relates to or is connected with trade and traffic or commerce in general, is occupied with business and commerce. Anderson versus Humble Oil and Refining Company. Estate, Black's Law Dictionary, 6th edition. Estate is commonly used in conveyances in connection with the words right, title, and interest, and is in a great degree synonymous with all of them. The condition or circumstance in which the owner stands with regard to his property. Boyd versus Seibold. Florida Administrative Code 12D-1.002 General Rules Definitions. Section 7. Homestead and homestead property means that the property described in Article 7, Section 6A of the State Constitution. Florida Administrative Code 12D-7.013 Homestead Exemptions. Abandonment. Section 5. Property used as a residence and also used by the owner as a place of business does not lose its homestead character. Section 5A. The head of the family occupying the second story of a building as his home and the first story of the building as his business house is entitled to claim homestead exemption on the building, except that portion not used by him either as his business house or as his home. Any portion of the property not used as his business house may not be exempted as a homestead. In other words, if any portion of the first floor or second floor of the building is rented to another party and used by the other party for the other purposes, it would not be within the exemption provided for under Article 7 of the state constitution. Smith versus Guckenheimer. Section 5B. The two uses should be separated, with that used as a residence and business house being granted the exemption and the remainder being taxed. Florida Statute Section 193.1554, Assessment of Non-Homestead Residential Property. Section 1. As used in this section, the term non-homestead residential property means residential real property that contains 9 or fewer dwelling units, including vacant property zoned and platted for residential use, and that does not receive the exemption under subsection 196.031. The Florida Administrative Code 12D-7.013, 5A-B, Homestead Exemptions, and Florida Statutes Section 193.1554, Assessment of Non-Homestead Residential Property, helps us to understand that homestead exemption is only for the head of the family, the owner, taxpayer, that has property, land, real property, and or personal property that is used for profit-making commercial purposes, or used by the taxpayer/owner as a place of business and in making a permanent residence upon such property, is entitled to claim homestead exemption upon the area of property set aside for the permanent residence, and the two uses, permanent residence and business, should be separated, with that used as a residence and business house being granted the exemption and the remainder of the property used for profit-oriented commercial purposes being taxed. Florida Statutes subsection 196.012, Exemptions Chapter, defines permanent residence to mean the place where a person, as defined by Florida Statutes subsection 198.01, subsection 3, and Florida Administrative Code 12D-2.001, subsection 10, has his or her true, fixed, and permanent home and principal establishment to which, whenever absent, he or she has the intention of returning. Section 13 defines real estate used and owned as a homestead to mean real property to the extent provided in Section 6A, Article 7 of the state constitution, but less any portion thereof used for commercial purposes, and goes on to define property rented for more than 6 months is presumed to be used for commercial purposes. Florida Statutes Section 193.1554 clearly defines non-homestead residential property to mean residential real property that contains 9 or fewer dwelling units, including vacant property zoned and platted for residential use, and that does not receive the exemption under Section 196.031, truly a business use of commercial property engaged in commerce. Black's Law Dictionary, 6th edition, defines commercial use as the furtherance of a profit-making enterprise, and defines the term commercial as trade and traffic or commerce in general, occupied with business and commerce. The homestead exemptions stated in the state constitution, state statutes, and the Florida Administrative Code would apply only to an individual person as defined by Florida Statute Section 198.01, subsection 3, and Florida Administrative Code 12D-2.001, subsection 10, as a company, corporation, or other legal entity who are taxpayers as defined by Florida Statute Section 192.001, subsection 13, and 220.03, subsection Z, and in possession of or with title to real property, real estate, as defined by Florida Statute Section 192.001, subsection 12(13), which is used strictly for profit-oriented commercial businesses such as a farm, ranch, lumber mill, car lot, automotive repair lot, grocery store, restaurant, hotel, apartment complex, office building, etc., with a part of such real property being used as the permanent residences of the taxpayer/owner, but less any portion thereof used for commercial purposes, would or could apply for a homestead exemption to receive, for lack of a better word, a discount, and in order to receive such an exemption, the title of such real property must be recorded in the official records of the county in which the real property is located, in accordance with the definitions stated in Florida Statute Section 192.001, subsection 12, subsection 13. Real property, real estate used and owned as a homestead. Florida Statutes Section 192.001, definitions. All definitions set out in Chapters 1 and 200 that are applicable to this chapter are included herein. In addition, the following definitions shall apply in the imposition of ad valorem taxes. Section 12. Real property means land, buildings, fixtures, and all other improvements to land. The terms land, real estate, realty, and real property may be used interchangeably. In general, a state may tax everything which exists by its authority or is introduced by its permission within its boundaries. While restricted to taxation of property having a taxable situs within the territorial jurisdiction of the state, the legislature may extend taxation to all persons and to all property, real or personal, within its jurisdiction. Frick versus Pennsylvania, Thompson versus Kentucky, and McCullough versus Maryland. Since a state can levy a property tax only upon property having a situs in the state, provisions requiring all property within the state to be subject to taxation will not be construed to include property which has no situs for taxation within the state. Taxing statutes and statutes conferring authority to impose taxes are to be strictly construed. Commonwealth versus Union, Department of Revenue versus Brookwood Associates, and Newport Illuminating Company versus Tax Assessors. Situs, Black's Law's Dictionary, 6th edition. Location or place of crime or business, or the right or power to tax it. Situs of property, for tax purposes, is determined by whether the taxing state has sufficient contact with personal property sought to be taxed to justify in fairness the particular tax. Town of Katy versus Alexander Construction Company. Business situs, Black's Law Dictionary, 6th edition. A situs acquired for tax purposes by one who has carried on business in the state more or less permanent in its nature. A situs arising when notes, mortgages, tax sale certificates, and like are brought into the state for something more than a temporary purpose, and are devoted to some business use there and thus become incorporated with the property of the state for revenue purposes. A situs arising where possession and control of property right has been localized in some independent business or investment away from the owner's domicile so that its substantial use and value primarily attach to and become an asset of the outside business. State versus Atlantic Oil Producing Company. Tax situs, Black's Law Dictionary, 6th edition. A state or jurisdiction which has a substantial relationship to assets subject to taxation. Taxation, general provisions, Florida Statute Section 192.032. Situs of property for assessment purposes. All property shall be assessed according to its situs as follows. 1. Real property in that county in which it is located and in that taxing jurisdiction in which it may be located. Florida Statutes Section 1.01 Definitions. In construing these statutes and each and every word, phrase, or part hereof, where the context will permit. Section 1. The singular includes the plural and vice versa. 2. Gender-specific language includes the other gender and neuter. 3. The word person includes individuals, children, firms, associations, joint adventures, partnerships, estates, trusts, business trusts, syndicates, fiduciaries, corporations, and all other groups or combinations. Individual, Black's Law Dictionary, 6th edition. As a noun, this term denotes a single person, as distinguished from a group or class, and also very commonly a private or natural person, as distinguished from a partnership, corporation, or association. But it is said that this restrictive signification is not necessarily inherent in the word, and that it may, in proper case, include artificial persons. As an adjective, individual means pertaining or belonging to or characteristic of one single person, either in opposition to a firm, association, or corporation, or considered in his relation thereto. Person, Black's Law Dictionary, 6th edition. In general usage, a human being, i.e. natural person, though by statute term may include labor organizations, partnerships, associations, corporations, legal representatives, trustees in bankruptcy, or receivers. In common usage, the term person does not include the sovereign, and statutes employing the word or ordinarily construed to exclude it. Wilson versus Omaha Indian Tribe. Florida Statutes, Chapter 198, Estate Taxes. Florida Statutes, Section 198.01. When used in this chapter, the term, phrase, or word. 3. Person means persons, corporations, associations, joint stock companies, and business trusts. Note: while the Florida Administrative Code 12D-2.001 subsection 10 definitions defines person as any company unless otherwise specifically provided, the word company may be used interchangeably with the word person. Florida Statute Section 198.01 subsection 3 Estate Taxes Chapter defines person to mean persons, corporations, associations, joint stock companies, and business trusts, keeping within the scope of the definition of taxpayer as defined in Florida Statute Section 192.001 subsection 13 and Section 220.03 subsection Z as a corporation or legal entity. The Black's Law Dictionary 6th edition defines person, though by statute term, may include labor organizations, partnerships, associations, corporations, legal representatives, trustees in bankruptcy, or receivers. Florida Statutes Section 192.001-12 defines real property as land, buildings, fixtures, and all other improvements to land. Section 192.001-12 also informs us that the terms land, real estate, realty, and real property, which are commercial terms, may be used interchangeably and shall apply in the imposition of ad valorem taxes. Real property, Black's Law Dictionary, 6th edition. Land, that which is incidental or appurtenant to land, that which is immovable by law, except that for the purpose of sale, implements, industrial, growing crops, and things attached to or forming part of the land, which are agreed to be severed before sale or under the contract of sale, shall be treated as goods and be governed by the regulating the sales of goods. California Civil Code Section 658. Florida Administrative Code 12D-2.001. Definitions. The following definitions shall apply to property assessed by the Department. 1. Operating property. All property owned by or leased to railroad and railroad terminal companies and directly related to the operation of railroads, operating property, shall be classified in one of the following categories: A. Real property. B. Tangible property. C. Intangible personal property. Subsection 10. Person, as defined in Section 1.01 Florida Statutes, and including any company, unless otherwise specifically provided, the word company may be used interchangeably with the word person. Note: this truly defines real property as a commercial term. The Florida Administrative Code 12D1.002 subsection 7 General Rules Definitions defines homestead and homestead property. Means that property described in Article 7, Section 6A of the State Constitution. Article 7, Section 6A speaks of only real estate, which may be used interchangeably with realty, real property, and land, but less any portion thereof used for commercial purposes, also keeping within the scope of the definitions provided in Florida Statutes 192.001, subsection 12 and 13. Florida Statutes Section 192.032 states clearly that the state can only levy a property tax, ad valorem taxes, upon property having a situs located in the taxing jurisdiction of the state. Notice: the Florida Administrative Code 12D-7.013-5 subsection B, keeping in context with 12D-7.002, exemption of household goods and personal effects, makes it clear that the taxpayer's permanent residence, shelter or dwelling house, the place that the taxpayer eats, sleeps, takes showers, watches TV, pursues hobbies, interests, and provides shelter for the family, shall be exempt from the tax, or as stated in Florida Statutes 196.192 subsection 1, shall be totally exempt from ad valorem taxation, or as stated in the Florida State Constitution, Article 7, Section 6A, permanent residence of the owner shall be exempt from taxation thereon. 12D 7.013-5B states that the two uses should be separated, with that used as a residence and a business house being granted the exemption and the remainder being taxed, stating that only business part of the property that is not being used for the residence or the business house may be apprised for ad valorem taxation, which by its own definition is a commercial tax. Property, that which is peculiar or proper to any person, that which belongs exclusively to one, in the strict legal sense, an aggregate of rights which are guaranteed and protected by government. Fulton Light, Heat and Power Company versus State. Property is the right to dominion over the use and disposition of an interest, protected by the Equal Protection Clause, which is grounded in stare decisis. See Cohens versus Virginia. Florida Statutes, Section 212.031, Tax on Rental or License Fee for Use of Real Property. 1A. It is declared to be the legislative intent that every person is exercising a taxable privilege who engages in the business of renting, leasing, letting, or granting a license for the use of any real property, unless such property is 2. Used exclusively as dwelling units. Florida Administrative Code 12D-7.001, Applications for Exemptions. Section 4. Each new applicant for an exemption under Sections 196.031, 196.081, 196.091, 196.101, or 196.202 Florida statutes must provide his or her Social Security number and the Social Security number of his or her spouse, if any, exercising a taxable privilege who engages in the business of renting, leasing, letting, or granting a license for the use of any real property. Here the legislative intent is made clear that a person who engages in the business, a business requiring a state license, of renting, leasing, letting, etc., or licensing the use of real property is exercising a taxable privilege known to most as an ad valorem tax, which is defined as by the Black's Law Dictionary 6th edition as a tax levied on property or an article of commerce. Florida Statutes Section 192.001(1) definitions makes it clear that the term property tax may be used interchangeably with the term ad valorem tax. Exempt. Black's Law Dictionary, 6th edition. To release, discharge, waive, relieve from liability. To relieve, excuse, or set free from a duty or service imposed upon the general class to which the individual exempted belongs, as to exempt from military service. To relieve certain classes of property from liability to sale on execution, or from taxation, or from bankruptcy or attachment. Ad valorem tax. Black's Law Dictionary, 6th edition. According to value, a tax levied on property or an article of commerce in proportion to its value as determined by assessment or appraisal. Callaway v. City of Overland Park. Florida Statutes, Section 192.001, Definitions. In addition, the following definitions shall apply in the imposition of ad valorem taxes. 1. Ad valorem tax means a tax based upon the assessed value of property. The term property tax may be used interchangeably with the term ad valorem tax. Florida Statutes, Section 196.192, Exemptions from an ad valorem taxation. In addition, the following definitions shall apply in the imposition of ad valorem taxes. 1. All property owned by an exempt entity and used exclusively for exempt purposes shall be totally exempt from ad valorem taxation. 2. All property owned by an exempt entity and used predominantly for exempt purposes shall be exempted from ad valorem taxation to the extent of the ratio that such predominant use bears to the non-exempt use. 3. All tangible personal property loaned or leased by a natural person, by a trust holding property for a natural person, or by an exempt entity to an exempt entity for public display or exhibition on a recurrent schedule is exempt from ad valorem taxation if the property is loaned or leased for no consideration or for nominal consideration. For purposes of this section, each use to which the property is being put must be considered in granting an exemption from ad valorem taxation, including an economic use in addition to any physical use. For purposes of this section, property owned by a limited liability company, the sole member of which is an exempt entity, shall be treated as if the property were owned directly by the exempt entity. This section does not apply in determining the exemption for the property owned by government units pursuant to Section 196.199. The principle is bottomed on the theory that the subject of ad valorem taxation is property and that of excise taxation is a right or privilege, or of a fee or tax exacted for the privilege of incorporating or doing business as a corporation. Harder's Fireproof Storage and Van Company versus Chicago, and South Covington at C Street Company versus Bellevue. Thus, it is well settled that a state may collect an ad valorem tax on property used in a calling and at the same time impose a license tax on the pursuit of that calling. Ohio tax cases. And see 51 American Jurisprudence 2D, Licenses and Permits, subsection 21. The Florida Administrative Code, state statutes, and definitions defined homestead exemption and commercial use as a procedure used in determining profit or nonprofit status of real property, such as real estate, land, realty. Profit being non-exempt from an ad valorem tax and nonprofit being exempt from all ad valorem taxes. The U.S. Supreme Court clearly defines that the ad valorem taxation is a tax on property used in the calling or business, and an excise tax is a tax on the right or privilege to conduct a business within the state. Ohio tax cases. The wording used in Florida Statutes 196.192, Section 1, exemption from ad valorem taxes states, all property owned by an exempt entity and used exclusively for exempt purposes shall be totally exempt from ad valorem taxation. And to help us better understand Florida Statutes Section 196.192, Section 2, also states all property owned by an exempt entity and used predominantly for exempt purposes shall be exempted from ad valorem taxation to the extent of the ratio that such predominant use bears the non-exempt use. Further, Florida Statutes 196.192 subsection 3 states that the natural person or the exempt entity is exempt from ad valorem taxation if the property is loaned or leased for no consideration or for nominal consideration. Take note, the words loaned or leased as opposed to rented or hire out. It then states, for purposes of this section, each use to which the property is being put must be considered in granting an exemption from ad valorem taxation, including any economic use in addition to any physical use, and then goes on to state, for purposes of this section, property owned by a limited liability company, the sole member of which is an exempt entity, shall be treated as if the property were owned directly by the exempt entity. Although an excise or privilege tax, like a property tax, is passed to raise revenue, it is to be distinguished from property taxation in that it is imposed upon the right to exercise a privilege, and its payment is made a condition of the exercise of the privilege involved. An excise tax partakes of the nature of a license tax and is laid on a license to pursue certain occupations, corporate privileges, sales, or consumption of commodities. Dorset versus Overstreet and Ingalls versus Riley. Further, Florida Statute Section 196.192 Section 3 ties the natural person, who would be the living, breathing man, woman, acting as the CEO, business owner, or stockholder, etc., of the corporation, association, limited liability company, joint stock company, business trust, or other legal entity, together as exempted from all ad valorem taxation of all property, personal or real, owned by such exempt entity, such as a natural person, if the natural person is an exempt entity and uses such property predominantly and exclusively for exempt purposes, as in religious, scientific, municipal, educational, literary, charitable purposes, or even a shelter, domestic household. Remember, the legislative intent stated in Florida Statutes 212.031 subsection 1a, it is declared to be the legislative intent that every person is exercising a taxable privilege who engages in the business of renting, leasing, letting, or granting a license for the use of any real property. The Florida State Statute, Section 196.012, defines exclusive use of property as the use of property solely for exempt purposes. Such purposes may include more than one class of exempt use. The Florida State Statute, Section 192.001, subsection 1, informs us ad valorem tax means a tax based upon the assessed value of property. The term property tax may be used interchangeably with the term ad valorem tax. Black's Law 6th edition defines ad valorem tax as a tax levied on property or an article of commerce in proportion to its value. The Black's Law Dictionary further defines commercial and commercial use as connected with trade and traffic or commerce in general, is occupied with business and commerce, a generic term for most all aspects of buying and selling, a profit-making enterprise. It would appear from the statutes and definitions shown here that ad valorem taxation, or property tax, is truly a commercial tax. Now, if the natural person or taxpayer's home or permanent residence is exempt from all taxation thereon in accordance with the Florida State Constitution, Article 7, Section 6A, then how could a non-taxpayer/owner of the family domestic household be confused with business and commerce and become eligible for a ad valorem tax or property tax, when the state statutes, government codes, and state constitution exempts the permanent residences or the shelter dwelling houses of the taxpayer from all taxation? Thus, it is well settled that a state may collect an ad valorem tax on property used in a calling and at the same time impose a license tax on the pursuit of that calling. The principle that the imposition of both an excise tax on a privilege, activity, occupation, or a calling and an ad valorem tax on property used in the exercise, conduct, or performance of such calling, privilege, or activity is not invalid as double taxation is generally recognized. Ohio tax cases. A state may not tax persons, property, or interests which are not within its territorial jurisdiction and subject only to applicable and controlling federal law. State taxation is authorized, limited, and regulated by the state constitution and by the statutes enacted thereunder. Gray versus Winthrop and Suttles versus Northwestern Mutual Insurance Company. Homestead, Bouvier 1856 edition. The place of the house or home place. Homestead farm does not necessarily include all the parcels of land owned by the grantor, though lying and occupied together. This depends upon the intention of the parties when the term is mentioned in a deed and is to be gathered from the context. Homestead, Black's Law Dictionary, 6th edition. The dwelling house and the adjoining land where the head of the family dwells, the home farm. The fixed residence of the family, with the land, usual and customary appurtenances, and buildings surrounding the main house. Homestead right, Black's Law Dictionary, 6th edition. The personal right to the beneficial, peaceful, and uninterrupted use of the home property, free from claims of creditors. Florida Statutes, Section 196.195, determining profit or non-profit status of applicant. 1. Applicants requesting exemption shall supply such physical and other records showing in reasonable detail the financial condition, record of operation, and exempt and non-exempt uses of the property, where appropriate, for the immediately preceding fiscal year, as are requested by the property appraiser or the Value Adjustment Board. 2. In determining whether an applicant for a religious, literary, scientific, or charitable exemption under this chapter is a nonprofit or profit-making venture, or whether the property is used for a profit-making purpose, the following criteria shall apply. The county property appraiser requires that a property owner/taxpayer wishing to claim a homestead must apply for a homestead exemption by submitting an application from DR-501 with the property appraiser of the county in which the property is located. The DR-501, or original application for ad valorem tax exemption, which is the homestead exemption form required under the Florida Administrative Code 12D-7.001 Section 4, and in accordance with Florida Statute Section 196.031. By submitting such application form DR-501, you're required to provide a tax ID number or Social Security number and reasonable details of the financial condition, record of operation, and the profit-making purpose of the property as stated in the Florida State Statute Section 196.195, subsection 1-2, determining profit or non-profit status of applicant, applying for a homestead exemption on the permanent residence of, and recording title or deed to such property in the county records in which the property is located. Could it be that you voluntarily become a taxpayer and thought this process you requested that such recorded property be entered on the county tax assessment roll? The answer is no. If the tax does not touch you, then you cannot volunteer for it. Just because a man and a woman buys a piece of land with a structure upon it to use as a shelter does not and cannot make him or her a corporation or other legal entity taxpayer as defined by Florida Statutes Section 192.001 Section 10 and 220.3 subsection Z, or a person as defined in Florida Statute Section 198.01 subsection 3, who is exercising a taxable privilege and engaged in business within the state situs pursuant to the legislative intent declared on Florida Statute Section 212.031 subsection 1A. It is a fact from the statutes and definitions shown here within, and that the United States Supreme Court, that an ad valorem tax or a property tax is truly a commercial business tax involving economic and profit-making use of real and or personal property in the exercise of, conduct, or performance of an act in commerce and levied for operating purposes upon the taxpayer for the privilege to facilitate business within the state. In order for a governmental entity to lay an ad valorem property tax, it must first be certain that the property being taxed is exercising a taxable privilege and being used for the furtherance of a profit-making enterprise in connection with trade and traffic, and or occupied with business and or commerce. Since a state can levy a property tax only upon property having a citizen in the state, provisions requiring all property within the state to be subject to taxation will not be construed to include property which has no citizen for taxation within the state. Taxing statutes and statutes conferring authority to impose taxes are to be strictly construed. Commonwealth versus Union and Department of Revenue versus Brookwood Associates Limited. When, however, the statutes enumerate the classes of property which shall be subject to taxation, property cannot be taxed unless it falls within one of such classes. Newport Illuminating Company versus Tax Assessors. Ownership. Black's Law Dictionary, 5th edition. The complete dominion, title, or proprietary right in a thing or claim. The entirety of the powers of use and disposal by law. The exclusive right of possession, enjoyment, and disposal. Ownership of property is absolute or qualified. The ownership of property is absolute when a single person has absolute dominion over the property. The ownership is qualified when the use of the property is restricted. Perpetuity. Black's Law Dictionary, 5th edition, page 1027. Continuing forever. Legally, pertaining to real property, any condition extending the inalienability. In terms of an allodial title, it is to have the property of inalienability forever. Nothing more need be done to establish the ownership of the sovereigns to their land, although confirmations were usually required to avoid possible future title confrontations. Florida Statutes, Section 196.011, Annual Application Required for Exemption, Subsection 3. It shall not be necessary to make any annual application for exemption on houses of public worship, the lots on which they are located, personal property located therein or thereon, parsonages, burial grounds, and tombs owned by houses of public worship, individually owned burial rights not held for speculation, or other such property not rented or hired out for other than religious or educational purposes at any time, household goods and personal effects of permanent residents of this state, and property of the state or any county, any municipality, any school district, or community college district thereof. Note: the state statutes, the state tax code, and the state constitution make it perfectly clear that the title to household goods and personal effects of the taxpayer, which are defined as creature comforts, things which give bodily comfort, such as food, clothing, and shelter, are exempt from taxation by the state and any entity under its authority, which means the counties and or cities. Florida Statute, Section 196.11, Section 3 states that it shall not be necessary to make any annual application for exemption on household goods and personal effects of permanent residents of this state or other such property not rented or hired out. And this tells us that the non-commercial property not rented or hired out and used predominantly for exempt purposes should not even be on the tax assessment roll. Wherefore, it would not be necessary to make an annual application for an exemption. The taxpayer's permanent resident, family home, shelter, dwelling house, is exempted from all taxation thereon, as stated in the Florida State Constitution, Article 7, Section 6A. Every person who has the legal or equitable title to a real estate and maintains thereon the permanent residence of the owner or another legally or naturally dependent upon the owner shall be exempt from taxation thereon. Florida State Statute, Section 196.031, Exemptions Chapter, tells us that every person who has the legal title or beneficial title in equity to real property in this state and who resides thereon and in good faith makes the same his or her permanent residence, or the permanent residence of another, or others legally or naturally dependent upon such person, is entitled to an exemption from all taxation. The Florida State Constitution, Article 7, Section 3B, states that those household goods and personal effects to every head of family residing in this state are exempt from taxation. The Florida State Constitution, Article 7, Section 5, states that the fact that no tax upon estates or inheritances or upon the income of residents or citizens of the state shall be levied by the state or under its authority. This means the counties and cities too. Remember the legislative intent as the state in Florida, State Statute Section 195.027 Rules and Regulations, is to be in compliance with the requirements of the general law and the Constitution. Taxing statutes and statutes conferring authority to impose taxes are to be strictly construed. Department of Revenue versus Brookwood Associates Limited. Private property. Black's Law Dictionary, 6th edition, page 1217. As protected from being taken for public uses is such property as belongs absolutely to an individual and of which he has the exclusive right of disposition. Property of a specific, fixed, and tangible nature, capable of being in possession and transmitted to another, such as houses, lands, and chattels. Scranton versus Wheeler. Property is the right to dominion over the use and disposition of an interest, protected by the Equal Protection Clause, which is grounded in stare decisis. See Cohens versus Virginia. Personal property. Personal property can refer to property which is not used in a taxpayer's trade or business or held for the production or collection of income. When used in this sense, personal property could include both realty, i.e. a personal residence, and personality, i.e. personal effects such as clothing and furniture. A right or interest in things personal, or right or interest less than a freehold in realty, or any right or interest which one has in things movable. The overall conclusion in which we are brought to is that the person and or taxpayer taxed in the Florida Revenue Code is a government employee or an agent, member, or stockholder in an enfranchised limited liability firm or corporation who is engaged in profit-making commercial affairs, as in exercising a taxable privilege. The residence, which is taxed under Florida statutes, are business locations, providing accommodations, apartment complexes, hotels, office buildings, etc., and consumption of the commodity at the retail level, grocery stores, restaurants, etc., and not tracts of land with structures devoted to mere shelter of its owner from the elements, dwelling home, and households. In fact, such use is not only not taxable, it is also not tax deductible as a business expense would be. Common sense tells us that households are not businesses, and the funds devoted to the upkeep and support of the ordinary household is not taxable in any state, nor is it a business expense which is tax deductible. Reading through the Florida state statutes, the Florida Administrative Code, the Internal Revenue Code, and the Florida State Constitution, you will not be able to find any references to taxation of the family-owned home, except to state the obvious exemption of the taxpayer's family-owned home as stated in the Florida State Constitution, Article 7, Section 6A. Permanent residence of the owner shall be exempt from taxation thereon. Nowhere in the state statutes of the State Constitution of Florida does it provide a procedure to assess and levy a commercial ad valorem property tax of any kind upon property used by its owner as a home or even a private business. There must be an economic use and a profit made from the use of the property to come within the state situs of taxation before an ad valorem tax can be assessed and levy upon any type of property. There must be clear evidence, a profit-making enterprise or some commercial use of the property, or the articles of commerce used in connection with the occupation, privilege, or act, which is taxed, enabling a tax for the privilege of incorporating or doing business as a corporation within the state, which is the essence of all taxation and the only lawful taxable activity granted by the state constitution to the state governmental entities. The principle is bottomed on the theory that the subject of ad valorem taxation is property and that of excise taxation is a right or privilege of a fee or tax exacted for the privilege of incorporating or doing business as a corporation. It is well settled that a state may collect an ad valorem tax on property used in a calling and at the same time impose license tax on the pursuit of that calling. Harder's Fireproof Storage Van Company versus Chicago and South Covington and C Street R Company versus Bellevue. The average working man or woman that owns land supporting a structure and used only as a shelter of its owner does not make a profit or income by legal or statutory definition from such use, nor is he or she exercising taxable privilege, occupation, or an act which is taxed in accordance with the state situs, nor does he or she live in a dwelling unit, family unit, or residential unit, or live upon real property or real estate, nor is he or she a person or a taxpayer as defined under the Florida state statutes, the Florida Administrative Code, or the Florida Revenue Code. The average man or woman that owns a home lives upon a non-commercial private property and merely hopes to be able to meet household necessities and provide creature comforts for the family such as food, clothing, and shelter as defined by the Florida Administrative Code 12D-7.002 and Florida State Statutes 196.181, leaving he or she seeking only the humanitarian goals of survival. Property ownership does not and cannot make you a taxpayer unless there is a clear evidence of some taxable privilege, occupational use, consumption of commodities, independent business, or some act connected with trade or commerce which is taxable under the state situs and a business license of some kind or a corporate charter to complete the loop. Florida Administrative Code 12D-8.001, all property be assessed. 1. General. A. The property appraiser shall make a determination of the value of all property, whether such property is taxable, wholly or partially exempt, or subject to classification reflecting a value less than its just value at its present highest and best use, located within the county according to its just or fair market value on the first day of January of each year, and enter the same upon the appropriate assessment roll under the heading Just Value. If the parcel qualifies for a qualified use assessment, the classified use shall be shown under the heading Classified Use Value. Section B. The following are specifically excluded from the requirements of paragraph A above. 1. Streets, roads, and highways. The appraiser is not required to, but may assess and include on the appropriate assessment roll streets, roads, and highways, which have been dedicated to or otherwise acquired by a municipality, a county, or a state or federal agency. A. The terms streets, roads, and highways include all public rights of way for either or both pedestrian or vehicular traffic. B. The phrase or otherwise acquired shall mean that title to the property is vested in the municipality, county, state, or federal agency and shall not include an easement or mere right of use. Section 2. Improvements or portions not substantially completed on January 1st shall have no value placed on thereon. 3. Inventory is exempt. 4. Growing annual agricultural crops, non-bearing fruit trees, nursery stock. 5. Household goods and personal effects of every person residing and making his or her permanent home in this state are exempt from taxation. Title to such household goods and personal effects may be held individually, by the entireties, jointly, or in common with others. Storage in a warehouse or other place of safekeeping in and of itself does not alter the status of such property. Personal effects is a category of personal property which includes such items as clothing, jewelry, tools, and hobby equipment. No return of such property or claim for exemption need be filed by an eligible owner, and no entries need be shown on the assessment roll. Tax exemptions, being in the nature of special privileges or immunities, must be strictly construed in favor of the sovereign in order to confine them to the limitations of our Constitution. Courts view with disfavor tax exemption claims which will be disallowed unless it has been clearly made to appear they are for a purpose recognized by our Constitution and statutes as being exempt from taxation. The Miami Battle Creek versus Lummis. As stated in the Florida Administrative Code 12D-8.001, all property to be assessed. B. The following are specifically excluded from the requirements of paragraph A above. 5. Household goods and personal effects of every person residing and making his or her permanent home in this state are exempt from taxation. Title to such household goods and personal effects may be held individually by the entireties, jointly, or in common with others. No return of such property or claim for exemption need be filed by an eligible owner, and no entries need be shown on the assessment roll. The Florida Administrative Code 12D-7.002 defines household goods to be the creature comforts of the taxpayer/owner, things which give bodily comfort such as food, clothing, and shelter, and states that the title to such household goods and creature comforts of the owner shall be exempt from all taxation. Remember the legislative intent as stated in Florida State Statute Section 195.027, Rules and Regulations, is to be in compliance with the requirements of the general law and the Constitution. The Florida State Constitution, Article 7, Section 3B, Taxes and Exemptions, states in plain language, there shall be exempt from taxation, cumulatively to every head of a family residing in this state, household goods and personal effects to the value fixed by the general law. Once again, the above codes and statutes, which must be interpreted within the scope of the definitions within the federal and state statutes and constitutional limitations of the duties, imposts, and excises, the supreme law of the land, makes it perfectly clear that the property appraisers and the tax collectors of any county of any state have no lawful authority to procure an assessment and collect a property tax of any kind on any non-commercial unincorporated property that is occupied and used exclusively as a dwelling shelter of its owner and the land it sits upon. Florida State Constitution, Article 7, Section 1A, Taxation, Appropriations, State Expenses, State Revenue Limitation. No tax shall be levied except in pursuance of law. No state ad valorem taxes shall be levied upon real estate or tangible personal property. All other forms of taxation shall be preempted to the state except as provided by general law. Florida State Constitution, Article 7, Section 1E, Taxation, Appropriations, State Expenses, State Revenue Limitation. For purposes of this subsection, state revenues means taxes, fees, licenses, and charges for services imposed by the legislature on individuals, businesses, or agencies outside state government. There is no lawful authority granted by and in accordance with the federal and or state constitutions that grants authority to any public official elected or appointed to exert acts of ownership or control of any kind of property not owned by them or collect any taxes not pursuant to the situs of duties, imposts, and excises. The Florida State Constitution, Article 7, Section 1A, states that no state ad valorem taxes shall be levied upon real estate or tangible personal property. So how can the counties and for-profit municipal corporations purportedly levied an ad valorem tax upon non-commercial land or building structures not used in connection with the occupation, privilege, or an act which is taxed, such as fees, licenses, and charges for services imposed by the legislature on individuals, businesses, or agencies outside state government, and be acting within the scope of Florida State Constitution, Article 7, Section 1E. For these public servants have sworn an oath to abide by the clearly established laws of the state of Florida, as stated in the above codes, statutes, and state constitution. Our property rights are inseparable from our substantive rights, and our substantive rights are inseparable from our property rights. Both types of rights are protected in the procedures and due process of the courts of common law in accordance with the Constitution of the United States of America. If the tax is in fact imposed on property, no matter what it may be called, it is a property tax, and courts will look through form to substance and will prevent that from being done by indirection which could not be accomplished directly. Dawson versus Kentucky Distilleries and Warehouse Company, and Choctaw O&G-R Company versus Harrison. Florida State Constitution, Article 1, Section 2, Basic Rights. All natural persons are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty, to pursue happiness, to be rewarded for industry, and to acquire, possess, and protect property, except that the ownership, inheritance, disposition, and possession of real property by aliens ineligible for citizenship may be regulated or prohibited by law. No person shall be deprived of any right because of race or religion. The use of one's land and property as a shelter of its owner from the elements, held and used only in the serving of the creature comforts of the owner for shelter and not used for a profit-oriented commercial purpose, is not a privilege or an act of commerce which is or can be taxed. And if you are a taxpayer by statutory definition, your home is clearly and expressly exempted from all taxation through the state statutes, government codes, and the state constitution. Land ownership in America is a God-given, constitutionally protected right in perpetuity, protected by all the state constitutions and the Bill of Rights. People, either a taxpayer or non-taxpayer, have to live somewhere and cannot be taxed for the mere privilege of existing. The Florida State Constitution, Article 1, Section 2, Basic Rights, states that all natural persons are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty, to pursue happiness, to be rewarded for industry, and to acquire, possess, and protect property. A substantive right cannot be taxed. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence and charter powers to the state. But the individual's rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. Reinfield versus Fisher. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no such duty to the state, since he receives nothing therefrom, beyond the protection of his life and property. His rights are such as guaranteed him by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law, and in accordance with the Constitution for the United States of America. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. Hale versus Hinkle. Wherefore, it is a fact that neither the state statutes nor the state constitution of Florida provides a procedure to assess and levy within the cities of the state a commercial ad valorem property tax of any kind upon non-commercial property used strictly as a dwelling home of its owner as a matter of right. Therefore, it is a fact that the public servants of the state of Florida, through a scheme of taxation with pure intent to defraud the people of the state of Florida, are collecting monies without lawful authority to do so, and are truly in direct violation of the supreme law of the land, and a clear usurpation of power not granted by the laws of the United States of America and the constitutions of the several states of the American Union. Private property is owned and controlled by private individuals. There is no monetary or proprietary interest that a government at any level has in controlling property belonging to a private individual. The property owner decides with whom he, she wishes to negotiate, procure a contract, dispose of, or improve property. Jones versus Mayer Company, 1968. The American people, newly established sovereigns in this republic, after the victory achieved during the Revolutionary War, became complete owners in their land, beholden to no lord or superior or fees, sovereign freeholders in the land themselves. These freeholders in the original 13 states now held a allodial title to the land they possessed before the war only feudally. This new and more powerful title protected the sovereigns from unwarranted intrusions or attempted takings of their land, and more importantly, it secured in them a right to own land absolutely in perpetuity. Anyone holding to the contrary is invited to evidence the law upon which they rely for their position. The end.